Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from INTERSENTIA. It's about European Union law, naturally. It's an important area of law and one that took my attention very quickly because of what it's about. It's a long title. It's the European Union law duty of consistent interpretation in German, Irish and Dutch courts. Now you'd think, well, what has that got to do with us in the England Wales jurisdiction? Well, it's got quite a lot to do with it because we are living in a global society today, and I think it's always useful to see the approach on interpretation and the requirements for some form of consistency, because one of the difficulties, one of the criticisms levelled at the members of the bar, is that we go about our business by creating illogical distinctions sometimes, by nitpicking in terms of interpretation of particular statutes and so forth, and generally trying to run rings around our opponents. Now, again, it's a bit unfair to say that, but at the same time you do get these basic points put forward. So what this book is trying to do is looking at what is called consistent interpretation. So the title I've given the review is Where Consistent Interpretation and Theories Come Together in European Union Law. Now we're still going to be governed by European Union law in England and Wales, excuse me, and of course the United Kingdom for some considerable time to come, even though we've left the European Union and the final leaving date is the 31st of December 2020. I'm recording this book review in the summer, but we've got quite a long way to go. Let's look at the book first. It's a paperback. There it is. There we go. That's the front. There's the spine, and then there's some detail on the back. Now you can hardly make any of that out, of course. It's the way it's designed. However, let's look at the book itself. There's a list of cases. It's a slightly different structure with INTERSENTIA works. The case law is at the back, and you've got it's structured by way of the ECJ, European Court of Justice, and then the actual areas by country. You can see the various countries mentioned there. Then you haven't got an index as such, but what you do, you can see there's paragraph numbering. If we go to the front, you see the front page there. The book's written by Sim Haket, I should have mentioned, European Law Duty of Consistent Interpretation. It's obviously covering German, Irish and Dutch courts. You've got the detail about the book there, then you've got an acknowledgement section, because there's a lot of work that's gone into this. There is no preface, you go straight into the work itself, and you see the chapters. Chapter 1 starts off with the introduction, what the book is about, and it's looking very much at it. I'll explain a little bit about that in a moment. You know, various chapters there, looking specifically at the various countries. Then you've got Chapter 6, a conclusion, and then you've got some various information at the back. The cases are at the back. Curriculum vitae is actually the detail of the author, Sim Haket, and it gives detail about him there. The list of abbreviations are covered well. I do think that's very important because there's a lot of abbreviation in this particular area of law, and it's very easy when you're looking at the problems concerning abbreviations. You think you might know what they are, but this is very helpful because sometimes you can have that little block or you think, well, what does that actually mean? And so I do think it's helpful. Then you've got the chapters. The introduction starts, what is this book about? And he talks about the germination, if you like, of the book, where it came from and why it's being produced. It is a heavy book. You can see that there's a lot of footnoting and a lot of detail. It's not the easiest book to read because obviously I would suspect it's been translated, and certainly obviously it is in English, but there will be a lot of linguistic issues which you get, unfortunately, with anything to do with EU law. But what do I say about the book? Having looked at it, I thought it was a very interesting book to review, because what you've got is Professor Haket offers us a most helpful title for those people who are researching EU law in detail from the German, Dutch and Irish courts' perspective. And of course the title considers the case law of the European Court of Justice, hence the fact that you've got the cases at the back of the book listed, which of course makes up the framework for the requirement to interpret national law as far as possible in conformity with the EU law directives. Now, I know that, as I've said earlier, that we are leaving, or we've left, still dealing with the final period before we finally leave, but at the moment, Britain, the United Kingdom, obviously has a lot of responsibility concerning what has made up part of our law from the European Union law elements, and therefore I think it's quite useful for the future for us to have some idea of where we're going to be going in the future, because clearly when it comes to interpretation there must be some sort of consistency by which you can measure the way in which decisions are arrived at. And what we get here is an in-depth analysis of the application of what is an obligation in 3 member states, that's Germany, Ireland and the Netherlands. The key question underlying this examination is to what extent the established theories of supremacy of EU law, national constitutionalism and constitutional pluralism adequately explain the relationship between EU and national law under the duty of consistent interpretation. And I'm sure everybody knows who followed the Brexit debate, one of the main issues was the argument that in Britain the supremacy of EU law overrode the common law in this country and the decision of the House of Lords, now the Supreme Court, the UK Supreme Court, as the final judicial body. Now clearly we are going to return eventually to a position where we do not have, under the Brexit concept, we do not have another jurisdiction telling us about our laws, and that was a major issue for the campaign to leave the European Union. Obviously we've still got to consider the relationship though that we have with the EU, and I think therefore this book will be of great use, because in order to understand the duty of what is called consistent interpretation and its interaction and or interference with national interpretative rules, the book includes an outline of the approach to interpretation in non-EU law contexts for the 3 selected member states. Again, that will be useful because we're looking at, in terms of the jurisprudence, at a much wider area. And of course, both the duty of consistent interpretation and national interpretative rules are complex creatures. That's what basically the editor, the writer says. And of course, it can be particularly difficult to disentangle how these national interpretive rules and the consistent interpretative approach will interact when you're disentangling the actual way in which we go about our business. And of course what the author has done is he's developed a typography or typology for understanding the different kinds of interaction, mainly yet not exclusively, by asking the question, under which circumstances can it be said that there exists a conflict of interpretive rules? And I think that's an important point from the jurisprudence position. And Haket also puts forward valuable lessons by discussing numerous judgments highlighting the mutual responsiveness of the duty of consistent interpretation and national interpretive rules, the 2 bits here we have, as well as the reconciliatory attitude of national courts, because at the end of the day the word consistent is the one that flows through all of the arguments that are being looked at. And he goes on to say, since the fit between consistent interpretation and theories on the relationship between the European Union and national law is examined, his work goes on to investigate the explanatory value of those theories beyond the context in which they're primarily developed and of course and or discussed, and therefore it contributes to what he says is an enriched understanding of those theories, and that's exactly what his mission statement is really about. The title is also of added value for practitioners, we feel, as it discusses in detail how the duty of consistent interpretation is applied before the courts. And that, of course, the application is one of the keys. The date of the publication of this paperback is the 30th of October 2019, and I'm recording it in the middle of 2020. There it is again. There's the front, the spine, and then the back. If I just open it in the middle, we're looking here, the Irish Superior Court's perspective, and a shift to a purposive approach in conformity with the directive. So the purpose body, you can see the structure, you've got the paragraph numbering and you've got the footnotes, you've got all of the detail, but you can see throughout the whole purpose is to attempt some form of, effectively, you can use different words, it's a form of standardisation. And that's what has always been the case with the concepts of European Union law. It's a massive task that has been undertaken. We are, within the United Kingdom, are basically backing away from this in terms of the decision to leave, the Brexit argument and so forth. But the longer term implications may well stay, because what we've got at the moment, and we will need to have, is some level of consistency throughout, not just member states, but non-member states as well, because we will be, by the end of this year, a non-member state likewise. So a big thank you to Sim and the people involved in the production of this work. I found it a fascinating book to read. I didn't find it the easiest book in the world to read, I'll be blunt, but I did find it very, very helpful. So a big thank you to all concerned. Bye-bye.